Good evening, everyone. Thank you for joining the Women's Resource Center tonight for Essential Estate Planning, Safeguarding Your Future. We're excited to have Jovanna Bailey here, an associate with Leach and Tishman. I just wanted to introduce myself. My name is Brent Jan Gregorio. I'm the Director of Client Services here at the Women's Resource Center. Just a few housekeeping items. Because this is a webinar format in Zoom, all of your lines are automatically muted. But we really do want to hear from you. We want this to be interactive. We want to hear your questions. So as we move through the presentation, there's a button at the bottom of your Zoom screen that says Q&A. And you open that and you can type your questions in there, and we'll be monitoring and answering those questions throughout the presentation. And then there'll be time at the end for additional questions. So please use that Q&A box as we move through the presentation so we can make sure we get your questions answered. And then the last thing is we do have a survey. So after I officially end the webinar, if you'll stay on 1 extra minute, once I end it, a screen is going to pop up on your screen with a very brief, short survey. We'd love for you to fill that out. Your feedback is invaluable to us to let us know what you liked, what you didn't like, and what we can improve with future webinars moving forward. So that being said, I want to go ahead and turn it over to Jovanna to start her presentation for us.
Thank you, Brent. And thank you for having me. I'm happy to be here sharing some of this information with everyone. So my name is Jovanna Bailey. I am a Trust and Estates Associate at Leach Tishman. My areas of focus are primarily trust and estate administration, succession planning, asset protection planning, and tax planning. So I draft wills, trusts, revocable trusts, different types of irrevocable trusts. I prepare tax returns for trusts for individuals if need be, and pretty much the full gambit of anything that's involved in both estate and tax planning, whatever that may be. So my firm is Leach Tishman. You can go to the next slide. And so this is just a little bit of information about me. There's my contact information. Should anyone have any follow-up questions, my email is jbailey@leachtishman.com. Feel free to reach out to me. Let me know that you were on the webinar with Women's Resource Center. You had some follow-up questions, and I'd be happy to either respond to your email or schedule a quick call with you and follow up. Also, just to let you know, I also volunteer with Women's Resource Center with the Ask a Lawyer program, specifically for trust and estates, either more often estate administration questions. But if you have questions about estate planning, I'd be happy to answer that as well. So you can also schedule an appointment through the Women's Resource Center if need be.
And then, Jovanna, I'm going to interrupt you for 1 second and just let everyone know that this is being recorded, and we will share out the recording with you afterwards, as well as this presentation. So if you do miss anything or you need to come back and reference this info, such as Jovanna's contact information, you will have that information. And like Jovanna said, she does volunteer at the Women's Resource Center as well. So you can always register for our Ask an Attorney program to set up a meeting with her. And with that said, I'll turn it back over to you, Jovanna.
No problem. And now you can go to the next slide. Right. Next. So just to tell you a little bit about my firm, we were founded in 1941. We're based in Pittsburgh, Pennsylvania. The firm's a national law firm and we're full service. So we have a presence just about in every state in the country. And we offer, we can assist with any type of matter, whether it be trust and estates, intellectual property, litigation. We can assist with various matters. We have about 140 lawyers that sit nationwide in about 10 different offices throughout the country. We have 9 major practice groups, which should be on the next slide, Brent. So these are our 9 major groups. We have a corporate group, construction, labor and employment, intellectual property, litigation, real estate, bankruptcy, and of course, trust and estates. So this is just a map letting you know that pretty much what our national reach is. So just about every state that's blue, every state that's blue, we have attorneys that are barred there that can, that are admitted to courts in those jurisdictions, and we can, transact business. Even if you're in one of the states that are still gray, we work with local counsel whenever is needed to, get things recorded or filed in courts in those states. But also because at least in my group, because we're tax attorneys and we work with federal law, we're still able to help with federal estate tax planning in the states that are gray. So we pretty much, like I said, can work anywhere here in the United States. Next. So I guess we're just going to get into it. Before I tell you what we're going to talk about today, I thought it was important to just say, what is estate planning? I know everyone hears it. Everyone's like, what is it? I think it's a will. I think it's a trust. Not really sure what it is. And so I figured I'd go over like the who, what, where, when, why, but we're going to go out of a little bit of order. And we're not going to ask all the questions, but we're going to start with what is estate planning and why do we need it? Next. So I have a definition up here, but to keep it short and simple, estate planning allows you to plan ahead for your future, and it allows you to decide how your assets are going to be distributed at your death. That's like the very plain basic meaning of estate planning. Most of the time when we hear estate planning, it's in regard to when I die, I want X, Y, and Z to happen. But also estate planning can be done with lifetime transfers. There's also, we plan for clients all the time where you may transfer assets during life to your children or to third parties in order to help either reduce your estate tax, federal estate tax, or reduce your estate, or for whatever reasons there may be at your death that you don't own this asset. So estate planning happens both at death and during lifetime. But the long story short is it determines where your assets are going to go when you're no longer on Earth. Next slide, Brent. So why is estate planning important? It generally avoids probate. So probate and estate administration are two words that are used interchangeably. They mean the same thing. Essentially, that means that if you die and you don't have a will in place or, any type of documents, trust, anything like that, and you own assets in your individual name, your family's gonna have to get an attorney to go to court to file documents to open a probate estate on your behalf and determine how you want your assets to be, not determine, in order to transfer your assets. Now, if you only had a will, what will happen is that your family will probate your will and your assets will be distributed however you directed or dictated in your will. If you don't have a will, then the assets are distributed pursuant to state law, which may or may not be how you wanted them to be distributed. So that's why it's important for you to get a will and or trust in place so that way you can decide that while you're not here. It also helps to prevent disputes. There are certain family members that think, oh, mom's going to leave me this, dad's going to leave me that, I'm supposed to get X, Y, Z. That's not always the case. So at least whenever you write down what your wishes are, typically family members will respect whatever you put on paper versus hearing it from a third party versus the courts telling them that this is just how state law goes. It just prevents any type of disputes amongst your family. It gives you the control over your assets, even though you're no longer here. It gives you a voice. Your voice does matter in those documents. Whatever you say is controlling, and the courts give not great deference, but that's the only difference. So essentially, whatever you say goes in those documents. And it gives you a peace of mind knowing that your assets are going where you want them to go in a manner that you want them to get there. Next slide. So I know a lot of people think, oh, I don't need to do estate planning. I'm not wealthy. I'm not rich. I don't have this. I don't have that. Long story short, estate planning is for everyone. If you have assets, estate planning is for you. If you have a bank account with $1,000 in it, $100 in it, $10 in it, estate planning is for you. If you have minor children, estate planning is for you. If you own a home, estate planning is for you. If you own any type of asset, estate planning is for you. It is not just a tool for the wealthy. And estate planning is also not just a will and a trust. There's also other ancillary estate planning documents as well, healthcare and financial documents that help in situations when you need them. And those all fall under the big umbrella of estate planning. Next, Brent. So when should you get estate planning done? So this isn't just something that you do once and you sit on a shelf and you come back to it whenever you pass. This is something that's fluid and should be updated very, very, very regularly. So When should you do it? Like I said, when you have assets, you have a home, you have a bank account. Like I said, it does not matter if your bank account has $100 in it or $100 million. Your account needs to go somewhere. So you need to make sure you're getting things in place in order to have it transferred at your death. When you have loved ones to care for, i.e. children, especially minor children, it's good to get documents set up so that way you can have a say in who's going to be the guardian of your children if you're not here anymore. You may know someone that you do not want to be a guardian for your child. And unfortunately, that may be the only person stepping up or the best fit person to be guardian when the time comes. And by setting up a will and excluding that person off of the list of, people that you would like to be guardian, or explicitly saying that you do not want this person to be guardian, the court will take great, great, great weight into what you're saying in your will or trust. So it's important if you have minor children. After marriage, it's important to update your documents to add your spouse as beneficiary. In Florida, we have something called an elective share. And so if let's for example, you don't update your estate planning, you did it before you got married, you died with a spouse, your spouse is entitled to at least 30% of your estate. So it's good to just go ahead and update your estate and make sure that, your spouse is accounted for. You don't want them taking the default statutory amount. If after the birth of a child, you want to go ahead and update your estate plan to add your child in, you're probably going to have to reallocate some of your assets. Maybe if you only had 2 children and everything was going one half, now everything will go a third, or third to each, or some other way, however you see fit. But it's good to do that as well. And after the death of a loved one. So if someone's passed, you want to make sure that you update your documents to remove them. Typically, whenever you have an attorney drafting your documents, they are going to include survivorship language. And so that's pretty much, it says that this person is entitled to XYZ if they survive you. And if they don't, that means that their distribution or their inheritance automatically lapses. So what that means is that they just don't get it. It just goes back into the pot. That's typically what happens. But if for some reason, that language wasn't included, it's just good to update your documents so that way you can account for, everyone's accounted for. Whenever you get a new asset, it's good to update your estate planning documents. You may have done your estate planning documents when you only had 1 or 2 properties. Now you've acquired, let's say 10, and you might want these additional properties to go to specific people. So it's good to update your estate planning documents so that way you can, make sure that those additional properties are going to the intended beneficiaries that you want them to go to. And then, like I said, just to reiterate, estate planning documents are not just something that you do once, you sit on a shelf and never think about it again. You need to update them regularly. It doesn't have to necessarily be every year, it doesn't have to be every few years, but when your situation is changing, when there's major life events, you should change them. And it's always good, even if there are no, new events, it's always good to at least get them looked at least, I would just say like every 3 to 5 years or something like that, just to make sure that they're in line with, current law, to make sure that they are in line with your current wishes. And so that's just what I would recommend.
And
Next slide.
Jovanna, real quick, we do have a question, and you may be
Okay.
getting this to later in your presentation. So if you are, we can answer it later on. But
Okay.
there's a question: what's the difference between a will and a trust?
Yes. So I will get to that later, but essentially the biggest difference between a will and a trust, I'll just go ahead and answer quickly now. The biggest difference is that a will is just an instrument that directs where assets go. So that's all that it does. You still have to go through probate. When you have a will, you still have to go through probate for the court to say, okay, let's transfer this to this person. When you have a trust is an actual transfer instrument itself. So the will just directs, a trust directs, and it transfers. And so because the trust is like a revocable trust is like a transfer instrument, you don't have to go to the court. So it takes away that court involvement that's needed, which is also a very expensive piece. So probate here in Florida costs somewhere between $5,000 and $7,000 for a formal, like a full-blown administration. And so that you're saving a lot of money by not needing court involvement.
Thanks, Jovanna.
No problem. You can go to the next slide. Okay, so Now that we've talked about the who, what, where, when, why, I guess we'll just talk about the agenda for the day. So I'm going to talk about just some basic estate planning documents. Like I said, an estate planning is not just a will, it's not just a trust. There's other healthcare and financial documents that are just as important as the will and trust. And then I'm also going to talk about something that's some people tend to overlook. It's the beneficiary designations on a lot of your accounts. People may not think that that's part of estate planning, but it really is. And so it's important to keep those updated as well. So that's pretty much what we're going to talk about. And we're going to take those in turn. So if you want to go to the next slide, Brent. So there's whenever you get estate planning documents done, typically it'll come with a will and or trust if you get one, and ancillary documents. Those ancillary documents can pretty much be broken into two categories: financial and healthcare documents. So a durable financial power of attorney is going to be your financial document, and that's pretty much a document that's going to appoint someone to make financial decisions on your behalf. Here in Florida, those well, I'm just going to call it POA for short. Those POAs are effective once you sign them. So if you came to my office right now at 6:20 and you executed a financial power of attorney and you appointed your son as your agent and the backup as your daughter, your son would have the authority to, and you signed it and you gave your son a copy of it, your son would have the ability to go to the bank and conduct financial transactions on your behalf. So it's important to know in Florida, there's two types of power of attorneys. There's springing and then there's non-springing. Springing only happen whenever you're in a jurisdiction that allows springing. Those take effect whenever you're incapacitated, and then at that point they have to prove incapacitation, et cetera, in order to make financial decisions on your behalf. In Florida, we're in a non-springing jurisdiction, and so that's why they're effective upon execution. And so this is important because in the event that you're incapacitated, or in the event that you need something, some type of financial decision made on your behalf, you need someone to go to the bank to get a money order to pay your rent because you're in the hospital, you can't make it there. You just think of whatever reason. You got in a car accident, you need someone to, handle paying your bills, keeping your business running, whatever the case may be. If you have a financial power of attorney in place, that person can just bring a copy to the bank and they can step in and get whatever you need. They can keep bills getting paid, they can get money orders, they can keep business flowing as usual with your finances. So that way that doesn't cause any type of disruptions that'll ultimately affect your credit and your rental history or whatever the case may be. So that's one form of estate planning that's very, very helpful for clients. That people don't think is estate planning is those financial power of attorneys. They are very, very helpful. And then also one important thing to note is that having a durable financial attorney helps prevent the costs associated with a court-appointed guardian. So if you don't, let's just say you get in a car accident, you're in the hospital, you're incapacitated, or you're just not able to make medical decisions on your behalf, your family members are going to have to, or the hospital will have to get a court-appointed guardian to make decisions for you. And I don't do guardianships, but last time I spoke with a guardianship attorney, I believe it costs about $10,000 to get a full-blown guardianship established here in Florida. That's a very, very expensive cost when you can get a financial power of attorney drawn up for a lot cheaper than that. And it just makes things a lot smoother and just keeps everything flowing as normal. You can go to the next slide. So now I talked about the financial documents. So now we're going to talk about the umbrella of healthcare documents. So the first one we're going to talk about is the Declaration of Living Will. This is what people call the pull the plug document. So this document pretty much specifies like what medical treatments you want or don't want whenever you are terminally ill or like incapacitated. Like most of the time, 99% of the time, the documents will really mention terminally ill. So whether or not you want to pretty much be like, stay on a ventilator and things like that, that's what this document goes through. It's good to have this in place because it prevents your family member from having to make that, difficult decision of pulling the plug. If you are someone that has a, larger family or, multiple family members that care deeply about you that are involved in this process, and they may, be split on the decision, like, half and half say yes, pull, the other half say no, that can cause a lot of family contention, a lot of family strife. And so having this document in place with your wishes laid out, if it's decided to pull the plug, it won't be your family members that's making the decision, it's you making the decision, and people tend to respect it a lot more. So it's important to have this document in place if you can, and it allows your wishes to be heard. If you're someone that doesn't want to be on a ventilator, once you're terminally ill for an extended period of time, you can make your wishes known with this declaration of will document. The next document is going to be the healthcare power of attorney. This document just designates who can make healthcare decisions on your behalf. So it's important to designate someone that, values your healthcare choices, someone that you talk to regularly, someone that knows what your opinions and what your thoughts are in certain things. So that way when they're making decisions, they're pretty much informed, and they're making decisions that are in your best interest based on what you guys have discussed. And it's important to discuss your preferences with your healthcare power of attorney as well. So that way they know, okay, this person likes this person wouldn't want this, she wouldn't want that. It's just important to have that. And then also it's important to make sure you designate a backup, just so that way if the hospital is not able to get in contact with whoever you designate as the initial agent, it's good to have a backup, so that way there's like at least 1 or 2 additional people that the hospital can contact to make decisions. Because once again, if there's no one, that can assist with this process, the court and the hospital has to take next steps. What will happen is they're going to have to get guardians involved. They're going to have to get a guardian involved, appointed and involved, in order to help make these decisions. They can't reach your next of kin. And, there's a bit of steps that get to that, but, you just want to kind of make this a lot simpler and smoother for your family. The next document is the Declaration of Pre-Need Guardian. And this document just pretty much designates a guardian for your person and property. So if we get to the point where we need to go to the court and get a court-appointed guardian, the courts will look at this document and see that when you were of your sound mind, you decided that you wanted person A to be your guardian, to handle all of your, finances and your property, make decisions for them, for you. And so they'll say like, okay, well, person A, then person B, and person C, and the court will take great deference and pretty much respect your wishes as much as they're able to. There's other restrictions with guardians, like there's criminal like background check requirements. There may be some financial requirements and things like that for people that can qualify to be guardian. But once the people that you designate actually meet those qualifications, the court will likely appoint them in the order that you have them listed on your declaration of pre-need guardian. And also, it's important to talk to the people or person that you designate as guardian. It's good to talk to them and make sure that this person knows that, hey, I'm, appointing you as the person that would pretty much handle everything for me. Should I need to go to the court and get a guardian, make sure that they're willing to do this, but also make sure that they're prepared. You don't want someone that's kind of getting sprung into the position, really kind of taking control of everything like that. You want to make sure people are aware of what's going on. Then the last one is going to be the HIPAA reform. And this is the Healthcare Information Privacy Authorization Act. I believe I said that correctly. But it's pretty much all of your sensitive healthcare information. This form designates who can access that information. And so you can determine if they can only access it while you're incapacitated, if they can access it when you're not incapacitated. You can set parameters around who can access your healthcare information and when, but this allows people to have access to the medical information that they need to make decisions. This is especially important if you maybe if maybe you get normally treated at hospital A, something happened, you got in a car accident, and you're at hospital B. Hospital B may not be in the same network as hospital A and may not have that same information. And so they may not have all the background information needed to properly make decisions moving forward. And so it's good for whoever your healthcare power of attorney is to also have HIPAA authorization, so that way they can call, request documents, get things sent over to the hospital, so that way everyone can be making informed and clear decisions. And you also want to update this regularly as well, so that way, with your healthcare power of attorney and HIPAA, as life changes happen, as you have different interactions with people, as your relationships change with people, you want to make sure that you're updating these forms accordingly. Next slide. So now we're going to talk about a last will. And so next slide. So I pretty much have like definitions on here for what a last will is, but to keep it short and sweet, your will dictates how assets are distributed at your death. They literally do just that. They just say that they say your name, they say you're a resident of such and such county, you're attesting that you are, of sound mind, and that at my death, you want assets to go here, 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 and here. In short terms, that is what happens with the will. In the will, you can name who's going to be the person that handles your estate. So Most people know it as executor. In Florida, we call it a personal representative, but you determine who's the person that's going to handle distributing out your assets, because they don't, once the court says yes, they can go to this person, somebody has to do it. So someone has to go to the bank and close accounts and give that money to the beneficiaries. Someone has to get with a realtor to sell a property to then distribute those sales proceeds to your beneficiaries. So there's someone who has to do some work, work on the back end in order to get that done, and you can decide who that person is. It's also important to have a last will if you have minor children, like I mentioned before, because you can designate guardians on who you would like to take care of them when you're no longer here. If you wanted to give, $5,000 to a family friend, $10,000 to a church, $50,000 to Women's Resource Center, you can also go ahead and put that in your will as well. And just to be clear, everything that I'm talking about right now can also go into a trust, but we're talking about a will. So I just wanted to make that a specific notation. But you can specify any type of gifts. If you want your house to specifically go to a certain person, you can say that I want my house to go here, but then I want everything else to get split this way. However you want your estate split up, you can do that. In Florida, your will has to be signed and witnessed and notarized. You actually have to sign it in the presence of two witnesses and notarized as well. So that's pretty much the standard here in Florida. I know, you watch on the movies where people do like the video wills, and in law school, we had cases where people were stuck under a tractor, and they would write their will on a tractor and, their wishes, or write it like on a napkin or something like that. That's not valid here in Florida. You have to go through all the statutory formalities of getting the witnesses, notary, et cetera, in order for it to be valid. And the good thing about your will is you can update it at any time. If you wanted to, you could do a will every single month of the year, every day, if you'd like to. There's always a statement in the wills that you're revoking any type of prior will or codicil that you executed by executing this will. And so because of that, you can change it at anytime that you want to. So next slide, Brent. So now we're going to talk about revocable trusts. And so I have, some information here on the screen, but as far as the definition of a revocable trust, to keep it short and sweet, it's a vehicle that allows you to manage assets during your lifetime and distribute the assets at your death. So you may have heard the term lifetime revocable trust, lifetime trust, living trust, revocable trust. They all pretty much mean the same thing. These are all assets that these are all trusts that you create during your lifetime. They're fully revocable revocable during your entire lifetime. Even you can amend it as much as you want to. If you want to just change one or two things, you can amend it. If you want to change pretty much the entire structure of it, you can just go ahead and revoke it and do a new trust. You can do whatever you'd like. But this is just something that allows you to transfer your assets a little bit more smoothly. So how these work is you typically fund them during your lifetime. And so what will happen is after you get the estate documents drafted and executed, then you'll have to make sure you fund your trust. So that's when, I'm not sure what areas you guys work in, but you may see that there's people that have their homes. If you look at a deed, it's titled, or your property tax bill is titled with their name as trustee of their trust. That means that they've now transferred their property to their trust. It's owned by their trust. You may see bank accounts titled in someone's name as trustee of their trust. That means that they've now transferred that bank account to the trust. You may see a number of assets that's titled in the name of the trust. And that's because they've now transferred those assets to the trust. And yes, it's owned by them as trustee, but if for some reason they couldn't serve as trustee of their trust, let's say they were incapacitated and their child had to serve as trustee, now the child can fully have access over that bank account, can go sell that house, can do whatever they need to, because it's not owned by the individual anymore. It's now owned by their trust, and it's governed by whatever the individual put into trust. So that's how the trust works. And because it's owned by the trust, and because you're going to keep it funded and add assets to it as you acquire them in your lifetime, the goal is that once you pass away, there won't be any assets that are outside of the trust that require probate, because everything got transferred to your trust during your lifetime. And then they'll just pass however you'd like them to. So whenever you pass, any assets that are owned by the trust are all going to be distributed as you dictated in your trust agreement. Now, let me just say that sometimes people, get their estate planning setup, they do trust, they do everything. They acquire assets after, and then they may have passed before they had the opportunity to update their documents. And what happens in that case is, which is what every estate practitioner does, we also execute what's called a pour over will. So instead of you just getting like a typical last will, what we'll do is something called a pour over will, which will tell the court it's more of a basic, it's way more basic than a normal will. All this will does is says, hi, my name is Jovanna. I have a revocable trust set up at my death. Any assets that are held in my individual name, please transfer them to my revocable trust. That's all it says. And then what will happen is whoever you designated as executor or personal representative will have to go probate your will. They'll get that asset, and then they're going to literally transfer it to the trustee of your trust. So that way it can be distributed in whatever terms you had there. So that's typically the combination. Whenever you have a revocable trust, there's a pour over will and there's a revocable trust. And then if you just have a standalone will, that's when your will say who gets what, where, when, how, and things like that. So it goes pretty much more into detail. So a big pro of having the revocable trust is that it avoids probate. Like I've been saying, probate in Florida, a full-blown administration is anywhere from $5,000 to $7,000. That's very, very, very expensive. And for estates that may not have a large amount of money, some beneficiaries may feel like it's not worth it to pay that much money to, invest that much time and energy into getting this done just to get like, a few dollars each if it's going to be split between multiple people. And then in those situations, your assets are just then sitting. If no one does anything, so probate is something that you have to actually go and do. No one's going to come to you, the court's not going to come to you and say, hey, such and such died, you need to initiate probate. This is something that you have to initiate, or the beneficiaries or the personal representative has to initiate on your behalf. It doesn't just happen. And then just like a will that I told you can do a will every single month, every day if you wanted to, you can do the same thing with your revocable trust. So you can change pieces of it, like I said, make amendments, or you can change the entire thing and do it completely new if you like, however many times you want to. What that's called is an amendment and restatement. So if you do decide that you want to do a full amendment and restatement, the way we title assets when we transfer it to your trust, you won't have to go back to the bank and retitle every bank account and go back and get a new deed completed for your property to retitle it. Like you won't have to do all of that. So we make sure that we think ahead to, if you do want to do like a full change of your trust document, you don't have to go back and do all of the administrative tasks that you did to get your assets retitled. And it's very, very, very important to go to a professional to get your trust and will done, because I know that there's like a lot of ways you can do this online. There's like LegalZoom. There's a lot of places that you can just kind of get a will done, and people do them and they think that, okay, I have a will, this is in line with my wishes, and they think everything is fine. But then we run into issues like the execution may not have been proper. If your will or your trust is not properly executed, then the courts just throw it out. It has no value. Now we're going to have to go back to the default statutory law, which is not good, especially when you took the time to, say who wanted what and where you wanted things to go. That's not a good thing. So it's good to go to a professional and make sure it's executed correctly. Make sure the language in the will is what you say. The language in the will says exactly what you actually wanted. Sometimes you can read something and you could think like, okay, this is what I wanted on the face of it. But then when you have to think about, you as estate planners, we always think about, okay, if this person's not living, then how's this going to look? If these 2 or 3 people are not living, then how's this going to look? And it's important for us to portray that to clients to let them know that, okay, is this what you're actually wanting? And sometimes when clients see that, they're like, no, I don't want it to go like that. I actually want it to be like this instead. So it's important to just make sure that your wishes are actually being conveyed in these documents. So that's why it's important to consult a professional. Next slide.
Jovanna, just to interrupt quickly, we have a few questions, and let
Okay.
me know if you're gonna get to these, and then that'll answer them later on. But the
Okay.
first one is, are there expenses involved to maintain a trust?
So while you're living, there are not any expenses. So, I mean, outside of the expense of getting the trust set up, there's no additional expenses. There's no tax returns that need to be filed. The tax identification number for a revocable trust is your social security number while you're living. So no tax returns, no like documents, nothing extra that needs to be done when you set the trust up. However, at your passing, there will need to be some administrative documents that's executed. Like we'll need to we'll need to execute like an acceptance of trustee document for whoever your successor trustee is. Banks and a lot of like insurance companies and other financial institutions are going to require that in order to pretty much like move forward. We'll also have to get an EIN, which is that's going to be the new tax ID for the trust. So we'll have to get an EIN from the IRS, and just some other, we may have to get like a administrative bank account set up. And so there is some cost involved at your death for the trust, but it's a lot cheaper than probate administration, and a lot faster as well. We don't have to wait for the courts to kind of get through their docket and get to our documents. You can get all of this done in like a week or maybe 2 days, depending on who you go to. It's a lot faster.
Nice. And you may be talking about this soon, but what's the difference between a revocable and irrevocable trust?
Okay, so I didn't include irrevocable trust in this presentation, but so I'm happy to answer that. So a revocable trust can be, like I told you, you can change it every single day if you want to. You can make amendments, you can do complete amendments and restatements. That's a revocable trust. Irrevocable trusts are typically tax planning devices or tools that we use in order to get assets out of individuals' estates, whether that's for state debt tax purposes or federal estate tax purposes. Irrevocable trust cannot be changed technically. So whatever provisions that you put in place, those are pretty much set in stone for the time, set in stone, and they're as is once you execute the document. In addition to that, they're not able to be changed, they also require ongoing administrative costs. So you'll have to file typically, a lot of people get what's called an irrevocable life insurance trust. That's to get the life insurance policy out of their estate if they have like a high dollar policy and other assets that can be kind of running close to that threshold. And just to give an example with life insurance trust, every year when you pay your premium, that's considered a gift to the trust. So now we have to file gift tax returns every year to report those gifts. So that's a cost. You'll have to either have a CPA or an attorney prepare that gift tax return. You also have to get an EIN for that trust once it's established. And so every year, if you've met I believe it's $600 of income or any taxable income. Actually, no, it's any taxable income for the year. If the trust has it, then you'll have to file a federal income tax return for that trust. And then any type of sometimes depending on who you put as trustee, there may be administrative costs depending on if the trustee is calling the attorney, trying to figure out can they do this, can they not do this, XYZ. So there are a costs associated with an irrevocable trust, but like I said, for tax planning, they can be a great tool. And then there's something called special needs trusts. Those trusts are set up for individuals that are on getting some type of government assistance or receiving some type of government assistance. The primary purpose of those is to ensure that the beneficiary's government assistance is not affected at all by them being a beneficiary of this trust. And in those cases, those are also irrevocable, but those aren't really tax planning tools. Those are tools just to make sure that, like I said, beneficiaries don't lose their government eligibility or their benefits. But that's another type of irrevocable trust that you may have heard a lot about as well.
Thanks, Jovanna. Another question we have from one of the attendees is, I own some life insurance policies, and if I put them under a trust, does that mean I change the life? Does that mean I change the life insurance ownership to the trust? Or should I list the life insurance when I open the trust?
Okay. So I think the latter part of the question may have been, do you list the life insurance policy? Do you list your trust as a beneficiary of the life insurance policy? So the answer to that question is it can be one or the other. So if we're doing tax planning for you and we need to get like I mentioned that irrevocable life insurance trust, if we're doing tax planning and we need to get that property or that asset out of your estate and you have no ownership of it, we'll change not only the owner of the policy, but we'll also change the beneficiary designation. If we don't need to worry about federal estate taxes or any type of state debt taxes in any way, shape, or form, it is perfectly fine for the individual to own the policy and have the policy payable to their revocable trust or to whatever, if they have an irrevocable trust or something like that set up, they can just have it payable to that irrevocable trust or or their revocable trust. So it really just depends on your financial situation. Like I said, for tax planning purposes, if you're close to that threshold, we get you, if you're close to that threshold, we change the owner and the beneficiary. But if we're not worried about federal estate taxes or state death taxes, we just normally just change the beneficiary designation.
Thanks, Jovanna. Another question we have is, if I put my house in a revocable trust, will the county be able to reassess the value as they do in a sale and then raise my real estate taxes? And also, does it change my homestead exemption by putting the house into a revocable trust?
No, it doesn't. So you don't have to pay any documentary stamp taxes whenever you transfer your home to your revocable trust. As well as the property appraiser will not, this is like one of those like exempted transactions. They're not going to reassess the value at all. So if you got your homestead exemption like 20 years ago and you're worried about them reassessing it for current value, you don't have to worry about that. And this does not affect, and will not have any effect on your actual property tax. So if there is any change, it's not because you transferred it to your trust. It's just because maybe it was going to increase on its own anyway. So I think I answered all of the questions.
Yes, I think so.
Okay,
Thank you. And
got
then
it.
the last question we have before we continue on with your presentation is, does every single will go to probate, even when the heirs in the will all agree?
Yes, it will have to go to probate. Reason being is, let's say you have an account, let's say you have a bank account. Okay, yes. Let's say you have a bank account at at any type of bank. It has, let's just say the account has $500,000 in it and it's owned in your individual name. You have no beneficiary designation for the account. Once you pass away, you have no joint owner for the account as well. So no joint owner, no beneficiary designation. What's going to happen is that once you pass away, that account is now owned by your estate. The only way the bank's going to do anything with that account is with a court document. And so that's the reason why you're going to have to go, not you, but your beneficiaries are going to have to go to court with your will. Or if you don't have a will, they're just going to have to go to court and petition for probate in order to either get the $500,000 in that bank account distributed pursuant to the statutory law, or pursuant to whatever's in your will. But that's the reason why. No, they're not going to talk to, even if it's your spouse, even if it's your, unless you're in a community property state, which here in Florida we're not, but even if it's your kids, even if they know you, they legally cannot do anything with those assets until they speak with someone that's legally allowed, like legally authorized to represent the estate. And the only time you can have that is when you go to court and get the court to appoint a personal representative. And that's the only person who can speak for the estate and distribute that money and go to the bank and say, hey, this $500,000 needs to go to person A, B, and C. Can you please prepare cashier's checks to these individuals? That's the only person that can do that.
Thanks, Jovanna. And thank you everyone for the great questions. Keep them coming as we move through the presentation.
Yes.
Are you ready for the next slide, Jovanna?
Yes.
Okay, wonderful.
So these are just some additional points that for me to talk about will go into a revocable trust. So your tangible personal property that you have, so your clothes, your household furnishings, paintings, artwork, your bicycle, things like that, that's all considered your tangible personal property. And in your trust and also in your will, if you don't have a trust, you can also designate who would get those items. So you can say that all of your tangible personal property will go to your spouse, or you can have your kids get it all equally. What will typically happen is they'll just sell it and split the proceeds, but you determine who will get things like your jewelry, personal property, your personal belongings, clothing, household furnishings. And if you have things that are like family heirlooms, like, a necklace or a piece of furniture that's just been in your family for generations, you can also do what's called like a personal property memorandum, and you can directly give that item to a person. Or you can honestly just put in your will that you want your daughter to get this, these earrings that's been in your family for the last 100 years. You just have to identify them, and then you can also put that in there. As far as distribution in your trust, distribution to the beneficiaries, in a trust, you can state whether you want that person to get it outright. So you can say whether or not, like, let's say you had a distribution of $10,000 for your daughter. You can either say, okay, well, trustee, at my death, you can give this to just write my daughter a check for $10,000. Or you can say, if you know that your daughter is probably not the most responsible with money, that, she may have a lot of creditor issues, then you might say, okay, trustee, how about you put we probably wouldn't do it for $10,000, but for hypothetical purposes, trustee, please put this $10,000 into another trust for my daughter's benefit. And please use this to pay for her health, education, maintenance, and support expenses. And then what will happen with that is that if your daughter needs her rent paid, she'll just go to the trustee and say, hey, trustee, I need my rent paid. Can I have a check? Trustee will write her a check because they deem that it's, for her maintenance and support, etc. In certain cases, your daughter might actually be the trustee of her own trust, which is perfectly fine. She would just have to, go to herself and say, hey, trustee, I need this money, and then literally just write a check from, she would just write a check from her trust account, sign it as trustee, and then deposit it into her individual account. She can do that, but that's very good for situations. Like I said, we probably wouldn't do it for $10,000 just because this would be an irrevocable trust that's created for your daughter's benefit, and we would still have those expenses associated, like I spoke about earlier. You're still gonna have to do an annual tax return, etc. So we typically do this for, a little bit higher amounts. And we also do this with money that can just be invested over time. So that way the goal is for it to grow. Hopefully the beneficiary doesn't fully deplete it. But what this is good for situations where like you want to make sure that, your money your daughter's inheritance, ensure that it doesn't go to like someone that's suing them from being in a car accident or like an ex-spouse or any type of creditor problem. You want to make sure that they just don't have that money in their possession. And so you keep it in another vehicle that they can access whenever they need to. Also, if you have a beneficiary that's, special needs or getting government assistance, that's where the special needs trust, you can also say, trustee, I want this $15,000 to go to disabled beneficiary. However, do not give it to disabled beneficiary because I don't want to disrupt their government benefits. So instead, put it in a special needs trust for the benefit of disabled beneficiary. And there are certain provisions and terms and things like that that are in there. And so the government will, when they see that it's a special needs trust and they see that it's, drafted in accordance with like the statutory requirements, that it'll be fine. It won't disrupt their any type of like income assistance or anything, or health insurance, things like that they're getting. And then last, if you are charitably inclined and you want to leave that $50,000 to Women's Resource Center or any other, entity, your church, whatever the case may be, whatever cause that you're interested in, if you have a donor advised fund, anything that you want to do that's charitably inclined, you can also include those provisions in your revocable trust as well. Next slide. So this is just like a quick overview. I know I talked about wills first and I talk about revocable trust after. So I wanted to just kind of do like a quick like side by side of like the difference. So like I mentioned earlier, the will directs distribution at death. The revocable trust actually transfers those assets, not only just at your death, but during your lifetime. So it's an actual transfer instrument. Wills will require you to go through probate. So that will include court involvement. A revocable trust avoids probate, no court involvement, with an asterisk if you fully funded your trust. Probates are public record. So if someone passed and their estate is going through probate, you can go on a clerk of court, for any county, look at the civil docket, type that person's name in, and you can see everything that they have going on, what assets they had, what the approximate value is, all of that. Revocable trusts are private. No one will know what's in your trust. No one's going to know the value of it. No one's going to know any of that. They can look in official records and see that your trust owns a house, and then they can go on Zillow and probably see that it's worth this much. But that's only if they're willing to put in all of that work. It won't be laid out nicely for them just on like, one specific site and one specific document. It's a very private process. And then as far as the will and a revocable trust, both of them can be changed or revoked at any time during your lifetime. So they're not permanent documents whatsoever. You can change them as you see fit. Next slide. So now we're going to talk about beneficiary designations. Next slide. And so it's important to note that assets with beneficiary designations fall outside of your probate estate. So these are not probate assets. Even if you don't have a trust in place, even if you have only a will, or even if you don't have a will, any asset with a properly, completed beneficiary designation will not be included in those assets. Those get transferred directly to your beneficiary. So your will and your revocable trust, irrevocable trust, whatever type of trust that you have, does not determine the beneficiaries for accounts that have beneficiary designations. So those are going to be like your retirement accounts. Now, you can have your retirement accounts, your life insurance policies, your bank accounts. You can have those as like transfer on death or pay on death to your revocable trust. But typically you might name a beneficiary, and then once you have it payable to your revocable trust, those assets will just be distributed however you have in your trust agreement. Then, but if you you also can do like, okay, well, I want, this half of my retirement to go to my son, half to go to my daughter, and they'll just get that money outright. Whenever you do that, you can't put restrictions on it and say, oh, well, I want it to be in trust to, keep the money away from your potential creditors, XYZ. So that's why in a lot of cases, it's good to have those retirement accounts or, those life insurance policies. You would change the beneficiary designation to your trust, have it payable to the trustee. Will, after you pass, the trustee will then go to whatever financial institution holds your retirement account, whatever life insurance company holds your life insurance, say, hey, I am the validly appointed trustee, successor trustee of this trust. Please make the proceeds payable to the trust. I'm here for a check. And they'll add it to the trust funds. And let's say whatever money that you had going to your son or your daughter, now you can add this money to the money that's going to be added to their trust. And then always be sure to completely fill out the forms. I can't tell you the amount of times we've seen incomplete beneficiary designations. We've seen individuals listed on beneficiary designations that are no longer living. And whenever they're incomplete, what will happen is that it'll just become payable to your estate. If they're incomplete and you don't fix it, that money is just going to become payable to your estate when you pass. So if you don't have a will, or if you do have a will, we're still going to have to go to probate to get those assets.
Jovanna, quick question, from one of our attendees. What does "if you fully fund your trust" mean?
When I say fully fund, I'm talking about, remember I said earlier that like when you get your trust set up, we need to go retitle like your bank account. We need to transfer your bank account to your trust, transfer your house to your trust, etc. There's instances where someone acquires assets after they initially fund it and they don't add those assets to their trust. So it's fully possible. Let's say you own 10 assets. It's fully possible for you to have like 5 or 6 in your trust because you had those when you set the trust up initially. And it's very possible to still need probate even with a revocable trust because you never added those remaining 4 assets when you got them a few years after setting up your estate planning documents, which is why it's very, very, very important to update these documents regularly. It's not just something you just sit on a shelf and just worry about later because, people are constantly selling things, buying things, and you want to make sure that those are accounted for. You don't want to have an estate plan that's essentially null and void because all of the assets typically there's what's something called a remainder estate. So either way, like your assets should fall into that. But if you had house 1, 2, and 3 going to these people, but you no longer own house 1, 2, or 3, those, those provisions are essentially void. And so you just want to make sure that your estate plan is actually meaningful and like tailored to your current situation at that time.
Awesome, thank you.
Okay, and then so this is just a little chart just to kind of visualize it. People don't think keeping their beneficiary designations updated is a form of estate planning. It is. There's some assets. There's sometimes people own assets that they don't necessarily require them to need a revocable trust. Sometimes everything that you own, you can literally just add a joint owner, or you can update your beneficiary designations, and then you might not own anything else. But it's good to at least have a will because for things like your tangible personal property, you want to dictate where they go, like the things that, if you have an apartment or something, the things that are in your home. It is important to note that, like, let's say all of your assets have a beneficiary designation or a joint account holder on them, and you literally have nothing that will need to just get transferred to someone because it already did by way of, their designation. You don't have to go to probate for tangible personal property or for your vehicle. So you don't have to go to probate. If that's all that you have, you don't have to go to probate for that. But for bank accounts, for house, for real property, for any type of substantial assets like CDs, brokerage, any type of like other asset outside of your car and like your household furnishings, clothes, and things like that, you're going to have to initiate probate proceedings. And so, like I said, people don't think of updating beneficiary designations as a part of estate planning. It definitely is. It's definitely a part of it. Like I said, some people actually have their trust as the beneficiary of life insurance policies and retirement accounts. And so that's just it's a part of the process. And this helps to avoid probate. So like I said, if you have incomplete beneficiary designations or designations that may have deceased individuals, etc., those are not helpful for you. You want to make sure you avoid probate at all costs. Common assets with beneficiary designations are going to be like your retirement accounts, life insurance, bank accounts. And then even in Florida, we don't have transfer on death deeds, but we have something that's called a ladybird deed. And what happens with a ladybird deed is that you pretty much give yourself a life estate in a property. You'll own it while you're living, and then once you pass, you'll say that it'll go to X person or Y person, or it'll go to your revocable trust if you don't transfer it while you're living for whatever reason. You'll say that it'll go to this person, and all that person has to do is record your death certificate with the county, and then the county will automatically update the property records whenever they do their search. I think every like month or week or something like that, it'll automatically be updated. So that's one way to do that with real estate. And then it also is important to know, like I said, I'm gonna say it again, accounts with beneficiary designations are not a part of your probate estate. Those are not dictated by your will or trust. Those are specifically dictated by whoever the beneficiary is on that account, and they're directly payable to that person.
Thanks, Jovanna. We got a question. You may have actually just answered this talking about the ladybird deed. But if you have a house and you don't have a will or a trust, upon your death, can it be transferred to your children if they're all in agreement without going to court?
No.
Oh,
So you will have to go to probate unless you have something like a ladybird deed in place. Outside of a ladybird deed, which I mean you would just go to like a real estate attorney, trust and estates attorney we prepare and record those too, very frequently as part of estate planning. But unless you have something like that in place, if this house was just owned in your individual name, and that's it, you will have to get it probated in order to transfer title. Now, a lot of title companies are still going to require, if this is your homestead property, title companies are still going to require your heirs, like your son and daughter, whomever, to sign the title documents for the property, but they also are still going to require you to open an estate. So it's like a 2-for-1. Like some of them will say like, oh, well, they're going to have to sign anyway, but then we also always run into the problem. Well, this was owned in someone's individual name. It needs to go through probate. So there's kind of no way around the house thing. The best thing to do, I would say, is to do a ladybird deed.
awesome. Thanks, Jovanna.
And then you can go to the next slide. And then I was talking, 1 second, before I open it up for questions, I was talking with Brent earlier about different legal resources that you can pretty much take advantage of in order to get estate planning done or have, questions answered about estate planning. One of them I thought of was, I know a lot of companies nowadays have some type of legal incentive, legal program that they offer to their employees. And so it would be good if your company has one of those, you can take advantage of it. Typically, it's very low cost / minimal cost for you to get very basic documents set up. Now, I don't think they're going to do any tax planning or anything extravagant, but for you to at least have the baseline documents set up, they'll get that done for you at like in-house legal departments, and they'll like draft them and everything like that. There's also Gulf Coast Legal Services and Minnesota Legal Aid that can also help with this for, I'm assuming, little to no cost, depending on what it is. And then if you have more information, if you want more information about like any of these documents or anything, of course you can contact me. Like I said, I work with the Ask an Attorney program with the Women's Resource Center. And so you can always schedule an appointment, and then you'd have my uninterrupted time for, 30 minutes, an hour for whatever you schedule for. And I'm happy to answer additional questions, but also Women's Resource Center has the Women's Money Empowerment program, which has a volunteer that knows a lot about this area, well, planning and things like that. And so she would be able to answer more questions, as well as there's Ask a Banker, who would also, she would be very well versed, I'm sure, with a lot of the, probably not necessarily the will and the trust, but a lot of the other ancillary documents and how those work and how functional they are in your estate plan as well.
Awesome.
And so does anyone have any, I know we've been asking questions throughout, but are there any additional questions?
Yes, please go ahead and pop your questions into the Q&A question box. Just as a reminder, if you raise your hand, unfortunately, there's no way to unmute the line. So use that Q&A box. A follow-up to the house question going to children without probate, which you answered, would still go to probate. So the question was, is it better to do a ladybird deed or a trust if you only have a house, like say that's your only asset, your main asset. Um,
So
it,
if you only have the house that would be in your probate estate, then yes, a Lady Bird deed is completely fine. No need to get a trust, no need to go get a whole trust up and set up and try to transfer all these assets in there. If everything already has a proper designation and that's really the only thing you're worried about, I would just say a Lady Bird deed would be sufficient.
Thank you, Jovanna.
Yeah, and they isn't like in estate planning, and I'm sure in other areas of the law, there's multiple ways to skin a cat. So there's multiple things that do the same thing, but they just might not be best for everyone. And so that's why in this situation, like I said, if that's the only item that the only asset that we're dealing with, it would be just fine for you to get a Lady Bird deed, but just know that a revocable trust can, accomplish exactly the same thing as well.
Awesome. And another question, is what about lifetime rights to an estate without a ladybird deed?
Do you mean like the beneficiaries being able to
I'm not sure. Maybe the attendee can clarify in the Q&A box, what they were exactly talking about. But the question was what about lifetime rights to an estate without a ladybird deed? I'm not quite sure. Maybe whoever asked that question, if you can type in maybe clarifying exactly what you're asking. Oh, if I have lifetime rights to live in the house.
If you have lifetime rights to live, are you saying that if you have a ladybird deed in place and you're asking what you can do as the person that holds a life estate, like the life tenant?
Um, will they have lifetime rights to live in the house, but not to sell it?
Are you asking me if that's what happens with a ladybird deed, or are you saying I
Um,
can't see the questions, that's why.
oh, I'm sorry. I'm
Yeah, I
sorry.
can't see them on my box. I'm
Well,
just
if you
going by
do
what you tell
not
me.
have a ladybird deed,
Okay,
what would happen in that situation if there's no ladybird deed and you have lifetime rights to live in the house, but you can't sell it, and there's no ladybird deed? Whoever owns that house upon their death, what would happen? Do you know?
okay, so it sounds like person A has a life estate. The facts are a little unclear to me, but it sounds like person A has a life estate in the property, if they can't sell it. And then the second person has whoever the remainder beneficiary is, will own it after person A dies. And in those circumstances, unless there's like multiple people with life estates, then whoever's that remainder beneficiary has full rights and ownership over that property and can sell it and, dispose of it and do whatever they'd like with it, if that's the case. If I'm
Got it. And there was a
correctly.
clarification there that said I have lifetime rights, but cannot sell it, and it goes to my stepchildren upon death.
Okay, correct. So yes, so they are the remainder beneficiaries, and I'm not sure if they're the joint owners, if they are the joint owners after your death, or if they are tenants in common, but essentially it will go to them equally. And if they're tenants in common, they'll just each have an undivided 50% interest in the property. If it's joint ownership, then they'll essentially own 100% together, and whoever's the first person to pass will just own the remaining. So when you have a tenant in common interest, you can, devise your 50%. You can put in your will that you want your 50% to go here, there, everywhere, but that's not the case with joint ownership.
Got it. And so another question is ballpark of how much I should expect to pay a lawyer to make a ladybird deed.
I think most attorneys probably going to charge you somewhere like maybe like $500. Probably in that ballpark, I think would be reasonable.
And then the similar question, how much would it cost to set up a simple will with a ladybird deed and maintain the docs, power of attorney, etc.? Do you think it's in that same ballpark?
I think if you want to get like a will and the healthcare documents and the Ladybird deed done, I would say probably somewhere within like the $1,000-$1,500 range, I think would be sufficient. It's obviously going to vary depending on where you go. And then it's also going to depend, like, I mean, you may think that you just need a will and, Ladybird deed, but then like whenever you start naming your assets and we get a full picture, there might be some additional things that's needed. Like I said, there may be some type of special disabled beneficiary or special needs beneficiary. Now we have to make sure we get a trust set up and XYZ. So just keep in mind that this is me quoting this off of hearing, very little information, but typically like clients normally think that they need one thing and they come in and we find a whole host of problems and we'll say, well, not problems, but additional things going on, and then we have to let you know that, okay, well, this may be better, that may be better, this would be a better option. So just keep that in mind.
Awesome. Thanks, Giovanna. And then I think back to the question about lifetime rights to live in the home, Ladybird deed. How is the deed amended? Is that something, do you know anything about that process?
You don't really amend a deed, you just like file record a new deed essentially. And so if you were gonna try to record a new deed, I'm guessing if you wanted to record a new deed, I guess like taking away your lifetime rights and maybe giving you like full ownership rights of that, I think you would have to, I'm not fully well versed in how that would happen. I haven't had to do that. And so that's something that I would consult with my real estate attorney just to get some like specific tips on that. But typically you would just file a new deed, and you would just have to include some type of language so that way whoever's looking at the deeds, whenever people are looking at them, they're understanding what's happening here. But there is a way to take away. I don't think you can remove your own lifetime interest. Someone else, like the remainder beneficiaries, are going to have to be okay with that. They're going to have to be okay with giving away their remainder interest and giving you a more than a life estate, because since you can't sell the property now, if they gave you anything more than that, you technically can do that. And so they would have to be okay with pretty much increasing your interest in the property.
Oh, great. Thanks, Giovanna. Another question here, sort of around ballpark costs, which I know is difficult to answer without knowing a lot of the specifics, but what do you think a ballpark cost for a lawyer to put a house in a trust as opposed to a ladybird deed?
Well, if you don't already have a trust, then you'll have to get the trust established. And so that would be a lot more that would be a lot more costly. So like I said, for Ladybird deed, it's probably somewhere in like the neighborhood of like $500 to get that done. And that's because all that requires is an actual deed to be recorded. So $500 plus cost. So there's going to be, you're going to have to draft up a deed and then just record it with the county versus like a revocable trust. We're not, I mean, our office, at least, we don't do just like, rubber stamped, like, we don't do rubber stamp, just like plain vanilla trust that like, we do for everyone. Everyone's trust is literally different. And so we would have to draft up a full revocable trust for you. We're not just going to be, adding the trust. We're going to think about where you want, tangible personal property, where do you want this to go? How do you want things to be distributed in trust? Outright, if you want to start doing in trust, and we're gonna have to be creating additional trust and things like that. And so that's why it'll cost more for you to get a trust versus just getting the Ladybird deed. But even with the trust and ancillary documents, depending on what's needed and what's going on, I mean, getting estate planning documents should still not be more than maybe like $2,000 or $3,000. It's not going to be like a $10,000 cost. It is an investment, but it is a very important investment, I will say.
Right. And I would also add to that, there are resources in the community, like Giovanna mentioned, Gulf Coast Legal Services, Minnesota Legal Aid, Bay Area Legal Services. Some of these nonprofit legal organizations may be able to help you with this at no or low cost. So definitely check out those organizations and see if they're able to assist. Well, we've got another question here, again related to the Ladybird deed, hot topic. But can you do a Ladybird deed if the house is jointly owned?
Are both of you going to be okay with if both of you are okay with it going to whoever that remaining person is? Yes, that would be just fine. But but when you say jointly owned, I'm assuming maybe like husband and wife or joint tenants with right of survivorship. Depending on what type of jointly owned, it's going to be, you're going to have both of the joint owners are going to have to sign off on transferring their interest to like a Ladybird deed.
Got it. Beautiful. Well, thank you for all the questions to all of our attendees. This has been great. I think there's some really great questions, and thank you, Giovanna, for this fabulous presentation. This last slide, we have Giovanna's contact information up there, but again, we will be sending out a recap with the recording, with this presentation to everybody within the next few days. Give us some time. We've got to edit things and upload things and put it all together. So give us some time, but it will go out to everyone that registered for today's webinar. We'll also post the recording on our YouTube channel, but you will get alerted via email when that happens. And I just want to thank everyone for joining us tonight. Special thanks to Jovanna for giving us her time and her expertise. And as a reminder, stay on 1 extra minute as I end this webinar, because we will have a brief, very brief survey for you. And we really appreciate any feedback that you're able to give us to help improve these and moving forward. So thank you again so much for your time, everyone. Thank you, Jovanna, and I hope everyone has a great rest of your evening. Take care.